Good morning. How are we doing? That's me. That's my face. Happy Tuesday. It is Tuesday on the Morning Night Live, and I'm here. Wake. Got my cup of reparations in the good old slut cup. Well, Salt Lake City, Utah cup. And I kind of was planning on watching the opening arguments of the Kyle Rittenhouse case because I wanted to hear what the prosecution says. And it's interesting because I have the feed on over here. In fact, here's the feed. Wait, why is my YouTube window messed up here? Hang on a second. Let me fix this nonsense. What the hell is going on? That should be there. I'm not even going to put it on the screen until I get it right. Let's see. Is that right? There we go. There's that. Is that? There's the bottom. And fix that a little bit. Make that a little bigger. Bring that up. Oh, man. Anyway. So that's what it looks like outside the courthouse right now. Apparently, Court TV. And let's see. Is anyone talking on this? No, they just got a live feed. It's on Yahoo, and that's a live feed. And so anyway, that's there. But when I was debating whether or not I was going to do this, I saw parts of the new documentary film, whatever, regarding Colin Kaepernick. And oh my, just a couple clips that I've seen so far. First of all, Ava DuVernay, a lot of people think she's brilliant, and let's put it this way. She is a brilliant filmmaker, person, type, director, producer, whatever. But what she does, at least as far as her documentaries, are very propagandist. I don't know. They're propaganda. And but the problem thing is she's really good at it, and she's really good at and the way she twists things or whatever, she tries to use facts. Like I watched 13th, and as I'm watching, I'm thinking, okay, she's got parts of this right, but some parts just painfully wrong. And so now I see parts of this. I'm going to watch it now just to see how crazy it is. But the two clips that I've seen so far, holy shit. The mental gymnastics and just lack of self-awareness that you have to even listen to this guy is just amazing. Now let's remind you who Colin Kaepernick is. So Colin Kaepernick, if you're not familiar and maybe you're not from the States, you don't know who I'm talking about. Well, Colin Kaepernick is the guy that he's a Super Bowl quarterback. Did they win the Super Bowl, or did they just get there? I think they lost. Did Colin Kaepernick win a Super Bowl? I don't know. He got to the Super Bowl. He was a quarterback that got to the Super Bowl with the San Francisco 49ers. I think he was a backup, and he got his chance to play about mid-season because I think the other quarterback got injured. He led the team to a Super Bowl. Had an impressive performance in the Super Bowl. And but he's not a great quarterback. And so the next season, they started Colin Kaepernick after his Super Bowl thing, and he started losing. He was because they realized that all he could do, he couldn't do a secondary read, so he just run all the time. And guess what? NFL defenses figured it out pretty quick, and so I think it was in the next season they went like 2-14 or something like that. Can you spell her name out in the chat? Are you talking to me? Anyway, and so, but he got mad because they benched him because he was having a shitty year and he was terrible, and they benched him. So during the season they benched him, he was also in the middle of a contract negotiation. And he didn't like how the contract negotiation was going, so he began to pout and sit on the sidelines through the entire game. And in fact, through the entire pregame and during the national anthem, he was sitting, right? And people are like, why is this dude sitting during the national anthem, not paying attention? And he suddenly had to come out, and he's like, oh, no. I'm not sitting. I'm not pouting because of my contract dispute. The Ravens won that Super Bowl. Oh, that's right. The Ravens did win that. Wasn't that the last year that, what's the linebacker's name for the Ravens? Very been in the league for a long time. Anyway, I don't know if it was the last year he played, but anyway. So he was sitting and he was having a contract dispute. So he started he was on the side. Well, then all of a sudden, they say, oh no, I'm not sitting because of my contract dispute. I'm sitting because Black Lives Matter. I'm sitting because of the police brutality. I am protesting police brutality. So that's where the whole take a knee to during the national anthem movement started with Colin Kaepernick, and it was all because of a contract dispute. Now, they offered a contract. He refused a contract. Okay, not Terrell Suggs. No, Ray Lewis, is that his name? Yeah, Ray Lewis. Anyway, so what started out as a contract dispute, he turned it around into a movement of taking a knee, and he was the head of that movement. And then no other teams wanted to pick him up because he was becoming toxic. And so then he began claiming that it was racism. It was racism. Oh, hang on. All right, now I wasn't sure how long this would take, but the Rittenhouse trial is starting. So I am going to, I'm sorry, we're going to go to the Rittenhouse trial just for a little bit. It looks like the judge is sitting down. I just want to hear the opening statement by the prosecution. Now, if you're not familiar, here, let's put the sound on for a second, see where he's at. Oh, I accidentally stopped this.
Game, which I shouldn't have. And
alleging here. And I think that exception has to be put into and part of the instruction. And as it reads now,
there's motions going on here. Hang on.
I don't think there is an exception. So I think that has to be included in the instruction if the court does not grant our motion for reconsideration.
And
okay,
the response is that I have not been able to complete what I wanted to do on your motion for reconsideration.
Okay,
I didn't get it until later last week.
I'm pretty sure the motion for reconsideration on the charge
didn't mean you didn't
of
file it. I mean,
possession of the weapon. I'm pretty sure that they're talking about here.
And I didn't have a chance to. I looked at it somewhat, but not all of it. And there is one other thing I would definitely want to check, and some other maybe. So I'm not in a position to give you a final ruling on that. I think I should instruct on it. But what you're asking for is actually exceptional language, which the instruction is not going to be frozen at the time that it's given this morning.
I'm sorry, there's a
So I think in order to
made a motion on how
with that particular case,
how to instruct juries to respond to something. I'm not
maybe
sure
I
what.
just should
We'll
leave
just
that
keep
one
listening.
alone because I'm leaving the ordinance violation.
So here's what I want you.
I'm
going to turn.
and I can just tell them I'll instruct them.
Something I want you to listen for, because in the filing for this lawsuit, for this charge, the prosecution.
I feel as though we've gotten a little bit lost in the weeds here. What the defense is alleging is an affirmative defense. If they want to raise that as an affirmative defense, they're welcome to do so. It is not the subject for a motion to dismiss. The complaint need not deflect or address every single affirmative defense. And this, so I believe there's no basis to challenge the complaint to actually get the complaint dismissed. If they wish to present a case, if they wish to raise an affirmative defense, which is that he was compliant under both of those.
Okay, they're arguing a motion here. Here's what I want you to listen for during the because when they filed this complaint, the lawsuit that the criminal complaint, they used the language of the reporter that was witnessing this, and in the complaint that they're going to watch, I think they hopefully they'll read it today. The prosecutors basically laid out the reasons, or at least it's almost like they laid out evidence that this was a self-defense. These are self-defense shootings, the way they described it. So I want you to listen for that, and I'm probably going to talk over it because I can't stop myself. So I'll put the volume back up, and we'll just talk over it when I need to.
Why we believe it's an affirmative defense and not a subject for a motion to dismiss. In terms of the curfew violation, we're wondering how we're going to do that, because that would be a 6-person jury, not a 12-person jury.
You don't think I can just pick a 12-person jury to decide it?
Well, it's a different standard of proof.
Well, that
Confusing. Anyway,
fucking curfew violation. Everyone had the fucking curfew violation. Who cares? Who cares? He's up for a triple murder. Who cares? Or double murder and
I understand the defense may not want this to be addressed at trial, and may not want the evidence in front of the jury, but we've met our probable cause. We've met our standard in the complaint, and it's been bound over. And now it's up to the defense if they want to try and raise this affirmative defense. We disagree that being 17 in and of itself raises affirmative defense. The state believes he'd have to present the certificate of completion of a hunter safety permit.
Oh, did I spell her name right? Good morning, Sean King. Good morning, Infamous One.
Thank you.
Okay.
Here, I'm going to turn this down for a little bit.
Yeah, I think what I'm going to do is refrain from giving any instruction on.
All right, real quick, let me say good morning to everybody while we're listening. Good morning to Let's Go Brandon, a.k.a. Renee Mariette, who gets the bell and was here first.
Yeah,
that's weak. Here, let's try that.
Well, I don't know if I can. That's probably
There, now you do it again. Also, good morning, Mike Savage. Blarg, good morning to Somnambule Nation. Wikipedia snippet. Select a boy. Yeah, boy. Also, good morning to
affirmative defense.
Aaron Meredith, hello. Good morning, Infamous One. Good morning to Advocatus Diablo, the Devil's Advocate. Hello, Mike. Oh, I said Mike Savage. Also, good morning to
legislative history.
5Z. How you doing, 5Z?
It's not an affirmative
Episcopos.
It is an affirmative defense.
Episcopos. I got it. There we go. Also, good morning, Rusty Shack, Jesse Leon. What's happening? Also, good morning to Katie Didscape, Tyler F.
In 3 different places.
By the way, welcome back, Katie. Nice to see you again. I know this is a tough time to watch anymore, but that means
for hunting purposes,
you.
It does not apply. Period.
Okay, hang on.
To 16 and 17-year-olds who possess firearms.
Okay, I'm listening to this now.
And I've provided that to the court.
Willett Forge, how you doing?
In the Act and in the Senate bill, Judge, and in the legislature.
Also, good morning, Sean King, Sidney Rochelle.
I'm going to give the instruction as I've stated it.
All right, let's turn this back up.
These are educational. They don't get a written copy, and they're just so they know what we're talking about when we talk about these charges. And at the close of the case, I can add whatever language is necessary, assuming that the motion is denied, which should. Then I'll add the language that clears up what exactly the full scope of the charge is. But I don't think.
I want to hear the charge too, and we may not. We
I
may
don't want to leave them
only do this today. I want to talk about Carlton
Kaepernick.
Kaepernick. If we don't get to it, we'll talk about it another day.
Misinstruct them on the other, but no matter what it is exceptional from the general language of the statute.
And Judge, I'm not going to argue with you about it. It makes it a strict liability offense today. If you're under 18 and you have a gun, you're guilty. And I don't think that's what the law is. So that's the problem that I have. The statute clearly lays out exceptions for that. And to just say he's under 18 and he had a gun, those are not in dispute, then he is, the way the instruction reads, there is no affirmative defense, whether it is or not, there is no defense.
No, unless he has the
No.
safety certificate. That's the last part of the statute. In Wisconsin, if you're under 16, you need to be accompanied by an adult to hunt, as long as you have hunter safety. If you're 16 and 17...
That's how you read it.
Right, not how we
That's
He
how
reads it
Ding.
differently.
That's how the DNR reads it.
Ha!
That's how they say it.
Yeah, okay.
So in
all
16
right.
and 17-year-olds, you can hunt alone with a hunter safety permit, which is what the last part of that statute calls
Yeah,
for.
well.
And that's being completely ignored in Mr. Trofsky's argument.
Okay. I am going to give some very incomplete language to acquaint them with the fact that there's a charge on the information respecting the possession of a firearm, and that I will instruct them concerning the elements of that offense at a later point. Okay. And the same thing will happen with respect to the forfeiture action. So, any other objections or problems with the proposed instructions?
Judge,
Yeah.
I didn't see on count 5 that you, on 1, 2, 3, and 4, you put an accept, or you give the self-defense instruction in some level. I didn't see that for count 5, however.
Didn't I have a general instruction on self-defense?
You listed them specifically for the charges or for the counts?
Did?
That's what I saw.
Boy, it was early this morning. It says counts 1 through 5.
So obviously they're just determining.
You're right. Let's see, count 5 is attempt to commit murder. That is going to have the same self-defense instruction as count.
Okay, so they missed something there, and they're gonna fill it in, I guess.
1, 3, and 4.
Very good. I just wanted to make
Yeah,
sure that.
you were correct in your observation.
Well, you tell me when you're ready, Judge.
Poor Kyle. This is the third time Kyle's yawned since I've been watching. He's tired. I'm sure it's tough to get
Okay,
sleep when
what
you're
else?
up for a triple.
One
or
last
double
issue,
murder
and that's
attempted
the court
murder.
has included, as it relates to, I think it's count 3, Mr. McGinnis. Count 2.
Advocate
Count 2. I'm sorry. 820. Jury instruction 820.
Trial by
is mentioned in
combat
there.
is so much simpler.
So, I guess the language in there that I'm having, maybe it's just me, difficulty kind of coming to some type of congruence with is the first full paragraph. The last
Rusty
sentence
Shaq,
says
Colin
the
Kaepernick
defendant
is
does
working to
not have a
establish a model,
privilege of self-defense as
a modern-day
to
Underground Railroad
Richie
for
McGinnis.
NFL slaves.
I don't know if
A
you see-
ticket
if you
costs
see
only
that.
$1 million. Was that a Babylon Bee article?
However, later on in the instruction, it says if the defendant was acting in lawful self-defense,
All right. So anyway,
conduct does not.
if he didn't see the
reasonable risk of
Colin
injury.
Kaepernick clips yesterday, I'm just gonna wait till they actually have some.
Concern I have is one portion
As they're going through the minutia here.
a privilege of self-defense.
Let's see if I can turn that down. Okay, so Colin Kaepernick in some clips yesterday. One, he was saying that being in the NFL was akin to modern day slavery because they have the combines that come out and measure what you can and can't do and whatnot. And so they I'll maybe we'll get to that if this is depending how long these opening statement is. And then the other part that I saw, what was it? What was the other part? He did the modern slavery. Hang on a second. Let's find Kaepernick. That was one. That was the modern slavery. There's also one where he was.
That's how I read it. I certainly don't think.
Oh, about TV shows. How TV shows starring black people, that they were only the acceptable blacks were the ones who acted white. And he came up with like 3 or 4 examples of Urkel and the guy on French Prince of Bel-Air, God, what was his name? Oh, I'll show you that one later. We'll get to that one. But I had to laugh because I'm thinking, so I've been going through lists and lists and lists of black characters that have been embraced by all Americans that didn't necessarily act all that white. Like, how about Sanford and Son? How about how about Good Times?
Right behind him.
Hang on a second.
And he.
What's he saying here?
The other person, the other actor, puts me in. I'm in fear of death from the assault by this individual.
Okay, this is.
I whip out a gun and I open fire, and I include in the zone. The danger zone is not only the actor with whom I have a perfect self-defense.
Carlton Banks, yeah.
Self-defense.
But then he had like 2D from Fats of Life and all that shit, and it was just like,
I think
come on, man. Think about all the characters that America has embraced. They've embraced the Cosby. They've embraced the Jeffersons. They embraced the Good Times family. They embraced Axel Foley, or even better yet, Reggie Hammonds, who was the character that everyone loved. Reggie Hammonds from 48 Hours, right? And think about which characters or which actors came on to be major successes after that. Even in that show, The Fresh Prince of Bel-Air, Carlton didn't come on to be successful. Will Smith did. Was Will Smith a acting white American? I don't know. It's crazy.
Have the children in the background.
All right, so what they're arguing here now is they're saying that they also endangered the life of the
I read 820
reporter.
to say that if the bad actor in your situation, if you were acting in self-defense, the instruction says that you did not then create an unreasonable risk to another. It's what it says. So I don't think then.
Well, why did they? I'm sorry. Go ahead.
No, so I guess what I'm saying is I don't think if it's self-defense on the bad actor in your scenario, then by that fact, according to 820, the instruction says your conduct did not create an unreasonable risk to another. So if we're talking about the children behind that bad actor, the statute says, or the instruction says then if it's self-defense, it did not create an unreasonable risk. And then there's a period. So
well, why does it say up above that the
Okay, there again, they're going through minutia. I just want to hear the opening arguments. I mean, this is all interesting.
In the second sentence,
as far as these motions.
The fact that the law may allow the defendant to use force.
The one thing I do like about this judge, first of all, if you're wondering, he was appointed by a Democrat in 1983. These in Wisconsin, they appoint these judges for life. So he's been on the bench for what, almost 40 years. And but a lot of people have been trying to make, the media's been trying to make him out to be a bad guy, to be he's a right-wing judge, blah blah blah, because they didn't like some of the rulings, like the ruling about whether or not you could call the 3 people who were shot by Rittenhouse as victims. And he said, no, you can't call them victims unless there's a crime.
Only if, according to 820,
They're all perpetrators.
only if the conduct against the bad actor was self-defense. That's the part I've read to the court. If the defendant was acting in lawful self-defense, his or her conduct did not create an unreasonable risk to another. Period.
I'm not sure what they're arguing about here. I mean, I kind of do, but by the fact, the little peeps are supposed to be the wise ones. Oh, someone needs to put a battery in the fire alarm. Interesting there, as I'm reading the chat on the Yahoo side, you can kind of see it over here. I'll put it on the screen for a second. It seems like most of the people who are watching this seem to be pro Kyle. Let's see. Someone here says it is legal for adults to carry firearms in public without a license if the gun is visible. However, to open carry, you must be at least 18 years old. Yeah, I don't know about that. There's and I'm not sure. Well, you know, that doesn't take away the self-defense. Hey, this is the one thing that people keep talking about. They keep talking about, well, Kyle didn't legally have a gun. Okay, so he could be found guilty on that charge. Does that take away his legal right to self-defense, though? I don't think so. I don't think so. Let's see. Interesting. They don't have to wear a mask in Kenosha.
The instructions committee. On page, well, I don't know if you've got the pages there, but well, I haven't. But near the end, it says.
Yeah, this is. I mean, the comments are like. It seems like 50-1 pro Kyle.
For example, assume that a defendant is charged with causing reckless injury to the victim.
Hey, Sherry Wilhelm. Thank you for subscribing. Are you here today, by the way, out of curiosity? Are you visiting? Are you in the chat, baby? If you are, just
criminal
put a
recklessness
thumbs up or a
requires
high
that the
in the chat.
defendant's
Thank you
conduct
for
created,
subscribing
quote,
today.
an unreasonable and substantial risk of death or great bodily harm, unquote. In considering whether the risk was unreasonable, the jury should consider the evidence that the defendant was acting in self-defense.
It's kind of crazy. Don't you know that's yelling people?
That's what I'm thinking. Is what they mean is.
So anyway, I'm going to watch this on Crowder, but it's better here. Drop the half homie that... Oh, they talk too much on Crowder. I like Crowdy, but they talk too damn much. I'll try not to talk so much.
Maybe it was what we once thought, but I don't think it's the law now, and that the jury, when they approach the McGinnis case, looks at whether
Renee, I kind of need one too, even though I don't smoke. I'll drink some coffee. How's that sound? Everyone, all right, everybody, raise your cup or glass or bottle or whatever you got, and we're all going to take a sip. 1, 2, 3.
Instead, the jury is told.
Good morning, random American. How you doing? No mask mandates in Wisconsin anymore, and fuck Evers for everyone instituting that. Oh my gosh.
Referred to it several times right here in our discussions in the last couple of weeks. One of the things the jury considers is what the defendant.
They're useless. We had to wear masks in the hospital yesterday, and I was like, okay, so I forgot to bring one in with me. So I go in the pharmacy or whatever it is, and I go to buy a mask at a gift shop or whatever the hell that is. And I go to buy one, and they're not even N95 masks. They didn't have any N95 masks. I asked, oh no, we just have those little cloth or not paper masks, you know, the little paper ones. I'm like, well, what the hell are these going to do? If this is a virus can get through this.
The conduct, and then they make their determination whether the fact that Mr.
He's got a brain fart.
Was, if they find that he was acting in self-defense, they can weigh that in deciding whether or not he recklessly endangered the safety of Mr. McGinnis.
If you act in self-defense, you can't recklessly endanger something. If they think that's okay, I don't know. Come on now.
But I'm going to try to skirt around those 6th and 7th counts because we don't have an instruction for number 7, and
so he'll have some instructions by the end of the
number 6.
Trial. Come on! I want the opening arguments. That's all I want. They better not take more than an hour.
I've had lots of statutory issues come up over the years, and this is the naughtiest. Okay. Other than that, any problem with the instructions?
Nothing. Nothing else from me, Judge.
State?
No.
Okay. Let's get the jury down.
Your Honor.
Before you do that.
Your Honor, I do want to put something on the record with regard to the jury.
Oh, yeah, I got something here, too. Yeah, what's up?
Your Honor, at the end of the proceedings last night, Brian Stute from our office came in to begin the process of setting up the audiovisual equipment and whatnot. While he was, I think entering the courtroom from the hallway, he passed by one of our jurors, and I'm going to identify this juror as juror 52.
What happened?
I can say more about that person's identity, but I don't want to do it openly in court.
Good, because you're not supposed to, dipshit.
My understanding is that juror 52 recognized.
Oh, shit, sorry.
How you doing? Like they knew each other, and I think Mr. Stute responded, politely in response, and that was the extent of their interaction.
Well, we can ask the juror.
Has explained subsequently that he had a previous employment where he remembers juror 52 from, and so that's the extent of their prior knowledge of one another. So I wanted to lay that on the record so that everybody's aware of that. I did tell counsel about that this morning before we went on the record as well.
All right, any question or observation?
Judge, do you feel the need to ask her if that would have any impact on her ability to serve?
I don't. You can ask you can ask me to ask her if you want me to, but I'll probably tell you no. Well, might as well be honest. It doesn't sound like anything, unless you have question about the accuracy of the report to me. I think it's a non-issue.
That's fine, Judge. We are ready to
People
go
are
forward.
arguing whether or not an
anything
AR-15
else?
is used for self-defense and
And
needs
I did
shadow
get a note.
Yahoo.
Do you know from whom this came?
Start the damn thing, right?
Well, I
That
don't know
fear
which one.
all fucking day. A filterable virus. Now, a virus that is small enough to pass through fine poured fiber is of. What the hell would happen there? Did they take the sound off themselves? It has to be. Yeah, they did. I don't know. This must be an off the record shit. I don't know. I think this judge is going to be fair, and
Yeah, thanks.
so we'll see.
You know he has a kill switch.
Oh, he has a kill switch, and somebody's hitting it. He's hitting it with something. Apparently, her voice is not to be heard. Yeah, we'll see the jury soon. A virus small enough to pass through fine port filter of diatomite or porcelain. American Heritage Dictionary. Thank you, Wikipedia snippet. I appreciate you bringing in definitions because.
Does this only suppress the sound while I hold it down, or does it click on and off? Press. And then if I put, and now I'm live again, right?
Yes,
Okay.
I can hear you.
I've got
We can hear you,
nice
Judge.
hand signals here from the respectful hand signals from the court TV crowd. Thank you.
It's on the back.
Oh. Somebody hit the kill switch again. So apparently Court TV, you can watch Court TV, but I don't know why Yahoo has this on here. Yahoo Finance. This is on Yahoo Finance for some reason.
I agree with your observation.
Oh boy, in the chat, Kyle should have taken out more. No, he should not have.
Okay.
He should
You know
only the people who've attacked him, and that's the other thing. You know, a lot of people who talk about this on Twitter, like, oh yeah, he's just went out there and shot people indiscriminately. Really? Because he's a racist. Really? How is it that he only shot the people who attacked him, and how is it that he only shot white people? It didn't really make sense. Someone over here, a minor with a weapon is a class A misdemeanor. Learn to pronounce minor wrongdoing.
Give them.
Whatever. What the fuck's with the audio? I don't know. Anyone know what sneed means? Someone's talking about sneed in the chat of the young. Come on, get on with it, or I'll go back to talking about Colin Kaepernick. Come on, bring the jury in.
It all makes sense once you.
I'm guessing.
Okay, well, I guess too, but
Sneed. Anyone know what that
okay.
means?
Let's ask the lawyers to come up.
Anyone know what this means? What? Ask the lawyers what? Oh, they're gonna. Okay, I don't know what the hell they're doing. Are they doing some shit for court TV? I hope not. Who's playing Pac-Man in the courtroom? No, I think someone needs to change the battery in the smoke detector. Oh, what happened? Oh, guess what? Apparently, Sneed is not something you can say. I got... The fuck is Sneed mean? Now I got to look this up. Because it would not let me put that word. What the fuck is Sneed? Now I got to look this up. I'll just leave the volume on. We're going to look up Sneed. S-N-E-E-D. What does that mean? Urban Sneed is a computer program developed by Toys R Us by Mike Drake. Okay. Okay, that just looked for... What is Sneed? Ask Reddit. Know your meme. Sneed, Feed, and Seed, formerly Chucks, is a joke in an animated television series The Simpsons. Questionable validity of the punchline and confusing nature of the joke structure has turned into a tool for trolling and memes, referencing an original quip which uses a scene from the show as exploitable in Photoshops and other edits. Okay, I guess. Oh, you could write it. Why would it let me write it? Maybe it won't let me write it. It's my fucking stream. Why can't I write what the hell I want? Good God, people.
Make a copy of both sides and then pick it back up, please. All right. I'll wait long enough for...
Yeah, check your logic. I did see the Hunter Avalone debated Gothics. I haven't watched it. I want to watch it now, but I'll have to maybe watch that in the morning at work or something. I picked a peck of snide in the snide field almost 8 miles wide.
You can give it to her when she comes down. All right.
This is fascinating. Oh! He's making a phone call.
Hello?
Would you come down, please?
You got it.
Thank you.
We need the door open. I don't know if somebody's standing over there or not.
Boy, there are some just, I don't say trolls, but just a lot of people in here, like, really invested in this trial. Or the homie shizzle Taekwon shouldn't get a murder charge if he uses a gun he got illegally, then say Rittenhouse should for some reason. I don't know that. Put gross creates in the... I'll just read some of the chat. Let's read some of the chat. I got an idea. Maybe from the Lorax. Yeah, that sounds like it. Maybe. Oh, is this the jury coming in? Where's the sound? Oh, that's them doing the sound. Everyone seems to be happy there. Even the murderer cracked a smile. Murderer? What murderer? You're not a murderer until you're convicted of murder, so there is no murderer. Let's see. Kyle shot at 4 little kids. No, he did not. Lobos died. Oh my God! Some of the chat is. I'm going to read some of the dumb shit from this chat. GOP loves violence. Really? I'm curious if all the riots for the last couple of years are from GOP then. I'm curious. Let's see. Actual Jake did a stream debunking her last month, I think, PDawgKnight. Yeah, I've seen it. I like Gothic. She's a friend and she was on the stream here, and I'll have to go check that out.
No, we're not using those. We're just using this area.
Judge Tyler with mob rule. He wants to set Kyle free, but the problem is that his bosses are liberals. Well, I'm not going to say that he's a liberal. He's been on the
person
bench
can
for
still sit up
almost
there.
30 years, and he was appointed by a Democrat. So
And then push that chair back.
at least they can't go, oh, he's a right-wing Republican, although they tried to say that. So the media's going after him. They don't, because they see the writing on the wall. There's no, I mean, if you really think about this, reasonable doubt, he has to be proven beyond a reasonable doubt
Use my response
to
on the
have
ones you
murdered the two people.
Okay.
Beyond a reasonable doubt. I don't even know how you do that.
Give each side
The charges
hunt it
by the
down.
prosecution, if you read the
With my response.
if you read the if you
Make
even
a copy for each side.
what's it called? If you read the complaint, the criminal complaint,
You can be
there's
seated.
self-defense
Good morning,
within the
everyone.
criminal complaint.
And
The gentleman with the scooter.
okay, and then we have to swear the jury.
Yep.
All right,
right.
here we go. Swearing the jury.
Maybe you can.
By the way, how many? Here, we don't need to see his face because I want to check something real quick. By the way, thanks for being here. Hit the like button if you like what we're doing. Share the stream, and I'm not so if you want to sponsor the show today, I'm not really giving the pitch today, but that's up to you, because this isn't even my content. Real quick though, I do want to thank people who tweeted out the
building
show.
is almost 100 years old. We're going to have our 100th anniversary.
Oh, I got someone answering me.
I
I'll get to
think
this one in a
year
minute.
after next. And then the chair is original equipment.
This is
and
hilarious.
Some of the furniture here. And then can you move that? Which is the most comfortable location? Would it be comfortable down there? Right there in front of the officer there?
We'll
Well-
just have to move the chair.
Yeah, well, that might. Will he be able to see everything from there? That's my only concern.
Your Honor,
Okay, yeah.
I just want to put the TV right in front.
Okay, perfect.
So, okay.
All right, great. I'll talk more about the building later. And that chair, when there's a break, we're going to move that out of there because I don't think I like it there. Yeah.
Did you fill in the sandwich?
I did. Thank you. That can go to the. Thank you. And then one of these. Okay, one of those to each side when there's a break or something. Good morning, everyone, and I'm glad I told you not to come in until 9:45. I did tell you that, didn't I? Oh, okay. All right. No, we were doing some legal stuff, and that happens periodically throughout the trial, and it's nothing exceptional. In fact, it usually ends up saving some time, some of your valuable time, and so we hope we.
All right, we're back here.
Oh, I see how it's laid out. Okay. We hope won't have too much more of that today. Would you? We're going to swear you now your oath to reach a fair and just verdict. So, if you would please,
Can I
Mrs.
ask all the
Lehman.
jurors to raise a hand, please, to take the second oath? Do you and each of you swear that you'll well and truly try the issue joined between the state of Wisconsin plaintiff and Kyle
So we
Rittenhouse
probably
defendant,
won't get through
and
much
unless
of the
discharged
opening
by the
argument,
court,
but
that
I'm
you
gonna-
really give according
Yeah,
to the
I'm
evidence
just ready
given
to
in court, so
bitch.
help you God.
Let's see what they say.
And
Because
please
it's going to be
silence
pretty.
those phones if you would.
Obviously,
Got 'em on
these
a-
opening statements take a
an
long
audible
time.
signal.
But
And,
I don't know how the
Before the trial
prosecution thinks they're
begins,
going
I
to
want to
prove
give you some
anything.
instructions which I hope will help you better understand your functions as jurors and how you should conduct yourselves during the trial. Your duty will be to decide the case solely as the evidence develops, presented at the trial, and the law is given to you in my instructions. Anything that you see or hear outside the courtroom is not evidence. Do not let any personal feelings about race, religion, national origin, sex, age, or politics affect your consideration of the evidence. Do not begin your deliberations and discussion of the case until all of the evidence has been presented and I have instructed
Turn on
you
your
regarding
picture
our
meter.
law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. There are times when I need to
So the
discuss
good
legal
news
matters with the
is,
attorneys that
they haven't shut down my
do
stream
not
yet.
necessarily concern you, or in some cases, actually.
Hey, Johnny Hellcat, good morning.
It's something
And John
needs
Arnott,
to be
good morning.
discussed outside your presence, and you'll be excused at that time. Usually, if it's going to be short, I'll just put you into the conference room back here, which is, it might be a little bit tight, but I think you'll be okay.
Something fascinating here.
Otherwise, we may take a break and you'll be up in your jury room. When you're in the jury room, you need to...
Real quick, I'm going to skip these instructions. I want to show you something here. Here's how Court TV, or at least the credit Yahoo Finance frames this. Trial begins today for Kyle Rittenhouse, the Illinois man charged with homicide after he fatally shot 2 men and wounded a third during street protests in Wisconsin 2 days after the police shooting of Jacob Blake. I guess that's fairly accurate. It's still, anyway.
And they know the procedure, and then go back directly to the jury room and remain in the jury room until you're dismissed for the day.
Hello, Jeff. Yes, it
do
is
not
the
research
Rittenhouse
any
trial.
information that you personally think might be helpful to you in understanding the issues which are presented. Do not investigate this case on your own or visit the scene. Do not read any newspaper reports or listen to any news reports on radio or television about the trial. Do not consult dictionaries, computers, websites, or other reference material for additional information. Do not seek information regarding the public records of anyone involved in this case. Any information that you may obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experiences as jurors while you are serving on the jury. Do not use a computer, cell phone, or other electronic device with communication capabilities to share any information about the case. For example, do not communicate by blog, email, text message, Twitter, or in any other way on or off the computer.
There will be no sequester of this
Do not
jury,
permit
I think.
anyone to communicate with you, and if anyone does so despite your telling them not to, you should report that to me. It will be tempting when you go home in the evening to discuss this with members of your household, but you must not do so.
Don't.
This case must be decided by you jurors based on the evidence presented in the courtroom. People who are not serving on the jury have not heard the evidence, and it is improper for them to influence your
So if you, because I know I'm not going to be able to continue through this whole thing today. I'm going to have to leave probably about
in any manner.
40 minutes after the hour of the next hour. This is on Yahoo Finance, on YouTube, and so you'll be able to find it if you need to switch over later. Also, Ricada Law is streaming it. I think Crowder is. I'm sure there's several. She'll be able to find it. But if you just want the raw feed, Court TV, then go to, without any commentary, you can find it on Yahoo Finance.
Third, any facts which the lawyers have agreed or stipulated, or which I direct you to find. Attorneys for each side have the right and the duty to object to what they feel are improper questions asked of witnesses, and to the receipt of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact that an objection is made. By allowing testimony or other evidence to be received over objection, I am not indicating any opinion about the value of that evidence. You jurors are the sole judges of the believability of the witnesses and of the weight of the evidence. You are not required to take notes during the giving of evidence in this case, but you are welcome to do so if you wish.
Sean, your question, I don't know. There isn't any. Is this trial? It's not about Jacob Blake at all.
You may use your notes.
It won't matter because they've already said that was there's no charges going to be brought against officers. The Justice Department said they're no longer
after the trial, your notes will be
investigating that case. They say that
You will not have
There's
a
no
copy
reason
of the
to.
written transcript of the trial testimony available for use during your deliberations.
And it's not
You
about
should
this.
therefore pay careful attention to all of the testimony because you must rely primarily upon your memory of the evidence
Oh, Monkey's
and
doing
the
it too.
testimony
Okay, cool.
introduced
You can
during the trial.
Go to Ranting Monkey also.
It is your duty as jurors to scrutinize and to weigh the testimony of the witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In determining the
can't wait
credibility of each
until
witness and the weight you give
Gross
to the
Kreutz
testimony of each, you should
testifies.
consider these factors.
That's the one test
Whether
I
the
wanna see.
witness has an interest or is disinterested in the outcome of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clarity or lack of clarity of the witness's recollections, the opportunity which the witness had to observe and to know the matters and things about which testimony is given, the reasonableness of the testimony, the witness's apparent intelligence, bias or prejudice.
I'm probably going to change the thumbnail of
prejudice,
this.
if any, is
name
shown,
of this stream.
possible motives to falsify, and all other facts and circumstances during the trial which tend either to support or to discredit the witness's testimony, and then give the testimony of each witness the weight you believe it is entitled to
Might have to
receive.
change.
There is no magical
do
way
Colin
for you
Kaepernick
to
tomorrow, 'cause
evaluate
I'm
the
not gonna watch the
testimony.
trial every
Instead,
day.
you should use your common sense and your experiences in life. In your everyday lives, you determine for yourselves the reliability of statements which are made to you by others, and you should do the same thing here. The first count of the information in this case charges that on the
This is what I hear the charges.
25th of August of last year at the city of Kenosha in this county, the defendant recklessly caused the death of Joseph D. Rosenbaum under circumstances which show utter disregard for human life. First-degree reckless homicide, as defined in the criminal code, is committed by one who recklessly causes the death of another human being under circumstances that show utter disregard for human life.
It's incredible.
Before you
that
may
that's
find
a
the defendant
charge.
guilty of this crime, the
There's
state
so
must
much
prove by evidence
video
which
evidence.
satisfies you beyond a reasonable doubt that the following three elements of this crime were present. First, that the defendant caused the death of another. Cause means that the defendant's act was a substantial factor in producing the death. Second, that the defendant caused the death by criminally reckless conduct. Criminally reckless conduct means that the conduct created a risk of death or great bodily harm, which was unreasonable and substantial, and that he was aware that his conduct created the unreasonable and substantial risk
After he was
of
chased
death or
down.
great bodily harm.
We'll get to that.
The circumstances of the defendant the third element is that the circumstances of the defendant's conduct show utter disregard for human life. In determining whether the defendant's conduct showed utter disregard for human life, consider these factors: what the defendant was doing, why he was engaged in that conduct, how dangerous the conduct was, how obvious was the danger, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. The second and third counts of the information, respectively, charge that at the same time and place the defendant recklessly endangered the safety of Richard McGinnis under circumstances which show utter disregard for human life. And the third count charges an identical crime involving an unknown male, and to each of these charges as well, the defendant has pleaded not guilty. Reckless endangerment of the first degree, as charged in these counts, is committed by one who recklessly endangers the safety of another human being under circumstances which show utter disregard for human life. Before you may find the defendant guilty of reckless endangerment of the first degree as to either of these counts, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant endangered the safety of another human being. Second, that he endangered the safety of another by criminally reckless conduct. Again, criminally reckless conduct means that the conduct created a risk of death or great bodily harm to another person, and that the risk of death or great bodily harm was unreasonable and substantial, and that the defendant was aware that his conduct created the unreasonable and substantial risk of death
running
or
away.
great bodily harm. A great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement, or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ, or other serious bodily injury. And the third element is that the circumstances of the defendant's conduct showed utter disregard for human life. Again, in determining whether the circumstances of the conduct show utter disregard for human life, you should consider what he was doing, why he was engaged in that conduct, the danger
didn't shoot till the other guy
the danger of the conduct,
turned back and pointed
how
the gun at
obvious
him.
was the danger, whether the conduct showed any regard for life, and all other circumstances relating to the conduct. The fourth count of the information charges that at the same time and place the defendant intentionally caused the death of Anthony M. Huber with intent to kill him. First-degree reckless homicide, as defined in the criminal code, is committed by one who causes the death of another human being with intent to kill that person or another. Before the defendant may be found guilty of intentional homicide of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements of this crime were present. First, that the defendant caused the death of another, and cause means that the defendant's act was a substantial factor in producing the death. And second, that the defendant acted with intent to kill another human being. Intent to kill means that the defendant had the mental purpose to take the life of another human being.
I think the judge wants to
was aware that his conduct was practically certain to cause the death
if there's a guilty
of another
verdict in
human
this.
being. While the law
Is the
requires
judge
that the
gonna set it
defendant
aside?
acted
It's
with the
almost-
intent to
it
kill,
seems to be
it
ridiculous,
does not
but we'll
require
see.
that the intent have existed for any particular length of time before the act is committed. The act need not have been brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not have been any appreciable time between the formation of the intent
Okay, that's
and
an
the act.
interesting.
The intent to kill may have been formed at any time before the act, including the instant before the act, and must have continued to exist at the time of the act. You cannot look into a person's mind to
Interesting.
determine intent,
Intent to
which
kill,
must be found
it can be
if it is to be found at all.
So he just said that it
from
could
the
be
defendant's acts,
hang on.
words, and statements, if any, and from all.
He just said that the intent to kill could have been the split second before he shot the gun. Okay, if there was an intent to kill and you shot someone once and you had an intent to kill them, would you not shoot again? Interesting.
Necessary to a conviction. While proof of his intent is necessary to conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances.
Interesting.
The fifth count of the information charges at the same time and place at the city of Kenosha in this county. The defendant attempted to cause the death of Gage P. Grosskreutz with intent to kill that person. This is a charge of attempted intentional homicide of the first
This is
degree.
the one that's the most
crime of
sketchy
attempted
of a charge.
Intentional homicide of the first degree, as defined in the criminal code, is committed by one who, with the intent to commit first-degree intentional homicide, does acts towards the commission of that crime which demonstrate unequivocally
Someone
under
pointing
all
a
of the
pistol at him.
circumstances that he had
How did
formed
they make
the
this
intent
charge?
and would have committed that crime except for the intervention of some other person or some other extraneous
And
factor.
again, you only shot him once.
Before you may find the defendant guilty of this
If
offense,
you're wanting to murder
the state
somebody,
must
wouldn't you
prove
shoot him more
by
than
evidence
once?
which satisfies you beyond a reasonable doubt that the following two elements of this crime were present.
He took one shot.
First, that the
on
defendant
Grosskreutz.
intended to kill another human being. Intent to kill means that the defendant had the mental purpose to take the life of another human being, or was aware that his conduct was practically certain to cause the death of another. Second, that the defendant did acts towards the commission of the crime of intentional homicide of the first degree, which demonstrate unequivocally, under all of the circumstances, that he intended to kill and would have killed another, except for the intervention of another person or some other extraneous factor. Unequivocally
If
means
his intent to
that
kill, he didn't try to kill him.
unequivocally
The
means
guy,
that no
he
other
shot the
inference or
guy.
conclusion
Guy got hurt,
can
and then he
reasonably
ran
and fairly
again
be drawn
instead
from
of
the defendant's
killing him.
acts under the circumstances.
Bless you, Judge. Oh,
Another
it's
person
God.
means anyone other
Uh-oh,
than the
COVID.
defendant and may include the intended victim. An extraneous factor is something outside the knowledge of the defendant or outside of his control. While the law requires that the defendant have acted with the intent to kill, it does not require that the
This is
intent have
fascinating.
existed for any particular length of time before the act is committed. The act need not have been brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute.
How about 30
There need not have
seconds?
been any appreciable time between the formation of the intent and the act.
no.
The intent to kill may have been formed at any time before the act, including the instant before the act, and must have continued
But
to exist at the time
the
of the
intent
act.
to kill must be.
Again, you cannot look into a person's mind to determine intent, which must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case which bear upon intent. Intent should not be confused with motive. While proof of intent is necessary to conviction, proof of motive is not. Motive refers to a person's reason for doing something, and while motive may be shown as a circumstance to
If
aid in
they find him
establishing the
guilty.
guilt of a defendant, the state is not required to prove motive on the part of the defendant in order to obtain a conviction. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. The sixth count charges that at the same time and place the defendant was a person under the age of 18 years and was armed with a dangerous weapon. The seventh count charges that at the same time and place the defendant intentionally failed to comply with an order issued by an agent of the state or of a local government unit
What?
which was engaged in emergency management activities under Chapter 323 of the statutes. The defendant has also pleaded not guilty with respect to each of those charges. I'm going to give you a more complete instruction about those offenses which are alleged at the close of the trial. Basically, the sixth count deals with the circumstances under which it is lawful for a person who is under the age of 18 to have a firearm in his possession. And the seventh count deals with special
If they're going to find him
circumstances in
guilty
which
of the firearm possession.
emergency management edicts are issued and the requirements which are imposed for obedience to those edicts. The first 5 counts of the information allege not only that the defendant committed the crimes which are charged in those
Let's see if I
counts,
can do
but
it in
also
small letters.
that he did so while using a dangerous weapon.
Okay,
if
it
you,
did let me do it in
if
small
you
letters, just
find the
not
defendant
caps. I
guilty
don't know
on
what
any
SNEEP
of those
means.
counts,
I don't get it.
then you must answer the following question.
It's still
Did
rampant
the
in the
defendant
chat for
commit
this
the crime while using
on
a
Yahoo.
dangerous weapon? Dangerous weapon means any firearm, whether loaded or unloaded. A firearm is a weapon which acts by the force of gunpowder.
Ooh.
Before
That
you
means
can
Alex
answer the
Baldwin
question
could be
yes, if you are
considered
called upon
guilty.
to answer it, then you must be satisfied beyond a reasonable doubt that the defendant committed the crime while using a dangerous weapon. Self-defense is an issue in this case, and the law of self-defense allows the defendant to threaten or intentionally use force against another only if the defendant believed there was an actual or imminent unlawful interference with his own person, and that he believed that the amount of force that the defendant and that he believed that the amount of force he used or threatened to use was necessary to prevent or terminate the interference, and that his beliefs were reasonable.
Terminator.
The defendant may intentionally use force which is intended or likely to cause death or great bodily harm only if the defendant reasonably believed that the force used was necessary to prevent imminent death or great bodily harm to
All right,
himself.
these opening statements are going to be a
A
long
belief may
time.
be reasonable even though it is mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances existing at the time of the alleged offense. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts, and not from the viewpoint of the jury now. The state must prove by evidence which satisfies you beyond
In
a reasonable
Wisconsin,
doubt
John,
that the defendant did
that's
not act lawfully in self-defense.
dispute is whether or not a 16 or 17-year-old,
That is with respect
as
to
per
counts
statute,
1,
can
3,
possess a
4,
long
and 5.
gun.
So those are
The
the charges of
statutes
reckless
say that they
endangerment,
can.
reckless homicide,
But the
and
dispute
intentional
is whether or
homicide,
not
and
that is strictly a hunting rule or not.
attempted intentional homicide. A separate instruction applies to, I'm sorry, I misstated that. The reckless, the instruction I just gave you on self-defense applies to the first count of reckless homicide involving Joseph Rosenbaum, the third count involving the unknown male, the fourth count involving Anthony Huber, which is a charge of intentional homicide, and the fifth count, which is attempt to commit intentional homicide involving Gage Grosskreutz. There is a different rule applicable to the charge involving Richard McGinnis, the second count, and that is that there may be evidence in the case that the defendant was acting in self-defense as to Joseph Rosenbaum. The fact that the law may allow the defendant to have used force in self-defense as to Joseph Rosenbaum does not necessarily mean that recklessly endangering the safety of Richard McGinnis was lawful. You must consider the law of self-defense in determining whether the defendant's conduct as to Richard McGinnis was criminally reckless conduct which showed utter disregard for human life. But the defendant does not enjoy the privilege of self-defense as to Richard McGinnis, because Richard McGinnis was not any way acting with aggression towards him. The law of self-defense allows the defendant to threaten or intentionally use force against another only if the defendant believed there was an actual or imminent unlawful interference with his own person, and that he believed that the amount of force he used or threatened to use was necessary to prevent or terminate the interference, and that his beliefs were reasonable.
Yeah, true.
A defendant may intentionally use force which is likely intended or likely to kill or cause great bodily harm only if the defendant reasonably believed that the force used was necessary to prevent imminent death or great bodily harm to himself. So that self-defense would be applicable to the defendant with respect to Mr. Rosenbaum, if you find that it's sustained by the evidence. But that doesn't follow through with respect to Mr. McGinnis, who was in the area of the gunfire. And so you have to analyze that separately.
Is he giving them a reason
and determine
to find him guilty on that count? I don't like that.
Keep in mind that a belief may be reasonable even though mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances then existing. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts and not from the viewpoint of the jury now. You should consider the evidence relating to self-defense along with all of the other evidence in the case in deciding whether the defendant's conduct created an unreasonable risk of death or great bodily harm.
I think it's amazing that they brought this charge of reckless endangerment of McGinnis, who was the reporter who was following around. He would have had to know McGinnis was there, first of all. How would he even know? He's focused on
did not
the first
create
dickhead.
An unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all of the evidence in the case that the risk was unreasonable. You should consider the evidence relating to self-defense as to Mr. Rosenbaum in deciding whether the circumstances of the defendant's conduct with regard to Mr. McGinnis showed utter disregard for human life. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense.
Well, they would have to prove beyond a
and you must
reasonable
be
doubt,
satisfied beyond a reasonable
amount,
doubt from all of the evidence in this case
beyond a reasonable
that
doubt
the circumstances
that he
of the
knew
defendant's
McGinnis was
conduct
there.
showed utter disregard.
How would he
for
show
human
utter
life.
disregard if he didn't know McGinnis was there? He would have to
In
prove that
reaching
they
your
know he was
verdict,
there.
examine the evidence with the utmost care and caution. Act with judgment, reason, and prudence. The defendant is not required to prove his innocence. The law presumes every person charged with the commission of a crime to be innocent, and this presumption requires a finding of not guilty, unless in your deliberations you find that it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you may return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the innocence of the defendant, then you must do so and find him not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or want of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called
Like the
upon
OJ
to
trial.
act in the most important affairs of life. A reasonable doubt is not a doubt which is based upon mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt, such as may be used to escape the responsibility of a decision. Examine the evidence and search for the truth, giving the defendant the benefit of every reasonable doubt. We're going to hear the opening statements of the lawyers now.
Hey! How long is this
And
going to
we
take?
follow the,
I'm going to see about 10 minutes of it.
Procedure where the
We'll see 20 minutes and then we got to
state
go.
speaks
But
first. Sometimes you see these.
thanks for hanging out. Like I
these,
said,
actor judges,
well,
actress
we're not
judges on
leaving yet,
TV, and they just destroy my enjoyment of the program when they tell the lawyers we're going to have the opening argument now. And I think, well, the only argument
Just
you're going to have
in case,
is
I'm
with
going to
me,
pin the link to
because
this
there's no such thing
in the
as an
chat.
opening argument. It's opening statement.
just so you know where we're watching it.
The argument is for the end, and that's when they're going to make their.
So if you decide
Please
to
to
watch this after you
return
leave this
verdicts in
channel, that's
accordance
the
with
link.
their
It'll
beliefs.
be in the pinned tweet above.
At this point, they're going to briefly acquaint you with what they
Briefly!
think the evidence is going to show, give you an overview, alert you to
Briefly.
the things they especially want you to watch for in the evidence.
Okay.
And they can be very useful to
Briefly.
you for those purposes.
Briefly.
And they're brief. And then we can right into the evidence right after that. Mr. Binger, I think, is going to address you first on behalf
All right.
of the state.
Here we go.
And then Mr. Richards will have the opportunity to make an opening statement now, or if he prefers, he is entitled to reserve his opening statement to a later point in the trial. And with that, again, no note. Well, you haven't got the papers yet anyway, but no note taking now because this is discussion by the lawyer. But please give them your attention. And with that,
All right,
Mr.
let's hear this.
Binger, you may proceed.
Here we go.
Thank you, Judge. Good morning, ladies and gentlemen. The evidence in this case will show that on the night of August 25th, 2020, here in our community of Kenosha, the defendant Kyle Rittenhouse, who was 17 years old at the time, had armed himself with an AR-15 style semi-automatic rifle loaded with 30 rounds and magazine. And using that rifle, he shot and killed Joseph Rosenbaum, an unarmed man.
Oh, an unarmed
The
man.
shot that killed Mr. Rosenbaum
Was he an unarmed black
was
man?
a shot to the back.
What?
This occurred after the defendant chased down Mr. Rosenbaum and confronted him while
That's
wielding
a
that AR-15.
lie.
The evidence will show that the defendant fled the scene of the dead body of Joseph Rosenbaum without stopping to offer any aid whatsoever.
He was being given
And as he's
aid.
running, word spreads from the crowd on the street that there is an active shooter running through the area. And the citizens there attempt to stop him. They approach the defendant,
who's on his back after falling
One person hits him in the
down.
back of the head. One person takes a swing at him with a skateboard. That individual is Anthony Huber. Eventually, the defendant loses his balance and falls to the ground.
Oh, that's not even the right order.
An individual who is the subject of count number 2, the unknown individual, runs in at that point and attempts to kick the defendant in the face while the defendant is on the ground. This unknown individual is unarmed. The defendant, in response, points his AR-15
Oh my God.
directly at this individual as this individual is literally flying over his body and discharges that gun twice.
Someone trying to kick him to the face. Yes.
Luckily, that individual was not hit. But clearly, if he had been hit, the wound would have been severe,
Maybe.
perhaps even fatal. Immediately after that, Anthony Huber, who is holding a skateboard, comes in and reaches for the defendant's gun.
He's holding a skateboard.
He grabs hold of the gun and tries to pull it away from the defendant. The defendant is wearing his AR-15 strapped to his body. There is a nylon strap around his entire body.
Okay.
The gun is slung from that, so it is essentially attached to him. Mr. Huber's efforts are unsuccessful because of that strap. And in that struggle, the gun winds up pointed directly at Mr. Huber's chest. The defendant pulls the trigger one time and discharges a round into Mr. Huber's chest, killing him instantly.
Is it?
A final individual by the name of Gage Grosskreutz
That's true,
has
but
followed this chase on foot and has approached the defendant at this time. Mr. Grosskreutz is holding his cell phone that he'd been using to record the night's events
and
for a live stream on Facebook in one hand, and a Glock semi-automatic pistol in the other hand.
Okay.
He runs up to the defendant. The defendant turns towards him with the AR-15. Mr. Grosskreutz raises his hand.
And Kyle doesn't shoot yet.
The defendant then turns his rifle over, begins to examine it for a second. Mr. Grosskreutz takes this opportunity, and you will see in the photos and the videos that he blades his body with his left hand, reaching towards the defendant. His right arm is pulled back. This is the one with the gun in his hand.
He pointed
And
the
as he's
pistol
reaching for
at
the defendant,
him.
the defendant turns the AR-15 and discharges the 8th and final round into Mr. Grosskreutz's right arm, the arm with the gun.
Oh my God.
Mr. Grosskreutz
He
runs off, screaming for a
he
medic.
tried to
The defendant
disarm
gets up
him.
and walks away.
Attempts to
On that night, he killed 2 unarmed people, shot at a third
unarmed. The guy who hit him with a
very
skateboard,
close range,
using it as a weapon.
and wounded Mr. Grosskreutz in the arm, who was armed with a gun. It is the state's position that this evidence demonstrates the criminal charges against the defendant.
Holy shit.
His intentional homicide of Anthony Huber and his reckless conduct towards the other defendants. Now, what I've just given you is the snapshot, but there's a wider context here.
Is there?
As we all discussed
'cause
yesterday, this occurs during the context of the events following the shooting of Jacob Blake,
a
which
black
occurred on
man
Sunday night,
by a white
August
police
23rd, 2020. And we all know that within a short period of time after that, the community erupted
on
in
fire.
protests, looting, rioting, arson, and violence. Sunday night and Monday night were 2 of the roughest nights that our community has ever seen. We are well aware of the damage that the uptown area along 22nd Avenue suffered. The probation and parole office on 60th Street.
I don't know that
furniture
he's necessarily
business
well,
there.
Did he lie? There's
Car
video evidence,
Source,
but
one of their
I did. He
locations
said
on
that
Sheridan,
Kyle
and other
chased
properties around
Rosenbaum
town
down.
that were
Why would he
damaged.
do that? What purpose would he
Fortunately,
have chased him
in
down
the entire sequence of events, this was all property damage.
for? And
one of the things we all agreed on yesterday is life is more important than property. Up until Tuesday night, despite all the things that the community had experienced, no one had been killed.
had any police officers there have guns
But what
to
happened
protect
as
property?
the time went on was that the people of Kenosha, who felt a sense of outrage, began to protest. But like moths to a flame, tourists from outside of our community
like the
were
two
drawn
of the three
to chaos.
the two of the
here in
three
Kenosha.
so-called victims.
People
were
from outside of Kenosha came in
Kenosha.
and contributed to that chaos. And it caused many of our citizens to fear for their safety.
Including?
Fear for their homes and their families.
Oh, okay, he got it.
Fear for their
He's
businesses.
not just saying that.
And take steps to protect themselves. Whether it is to arm themselves, board up their windows, move, or take time away from the community.
Well, now he's just telling you why Kyle was there.
All of those reactions were entirely understandable and reasonable.
Okay, so that was reasonable for Kyle to be there to help.
And no one here is going to tell you otherwise. As long as those are what you're left doing, there's no issue.
Well, what if someone attacks you?
But out of the hundreds of people that came to Kenosha during that week, the hundreds of people that were out on the streets that week, the evidence will show that the only person who killed anyone was the defendant,
Okay.
Kyle Rittenhouse.
And?
The evidence will show that hundreds of people were out on the street experiencing chaos and violence, and the only person who killed anyone was the defendant.
That's
Kyle
irrelevant.
Rittenhouse.
What's that mean?
We will show you videos of some of the events that night, of police, tear gas, rubber bullets, and yet the only person who killed anyone was the defendant. There are fireworks going off, which is a loud noise, sounds like gunfire. There are guns being discharged, the sound of gunfire.
Thanks,
throughout our
Arnott,
community
who says, thanks for
Hundreds
the
of
show,
people
P-Dawg. Appreciate
are
you,
there
Arnott.
experiencing this.
Big
and
love,
yet
brother.
the only one who kills anyone
is the only one who was attacked personally.
We will show you video of hostile confrontation between literally hundreds of people on one side of the issue and on the other side of the issue. People getting up in each other's faces.
And
yet the only person who killed anyone is the defendant.
And it doesn't take away self-defense.
Hundreds of people experienced those nights, experienced the night of August 25th, experienced that chaos. Hundreds of people. And yet the only one who killed anyone is the defendant, Kyle Rittenhouse. Recently, I heard someone sort of tongue-in-cheek joke that jury service is bringing in folks from our community and paying them $8 a day to help solve a murder. We're not asking you to solve a mystery in this case. In most homicide cases, the elements that I need to prove might be a little challenging, but here, there's no doubt, there will be no dispute in this record that the defendant had that gun that night, shot 8 bullets, 4 of them hit Joseph Rosenbaum, 2 of them at an unknown individual, 1 into Anthony Huber's chest, and 1 into Gage Grosskreuz's arm. That will not be in dispute.
Did you say someone hit an unknown individual? And why don't they know the individual?
In this case is going to be self-defense.
Yeah.
And the judge has given you an instruction, which I want to highlight here, because there are some factors that I'd like you to keep in mind when you hear the evidence in this case. The defendant used deadly force.
And?
There is a privilege under our laws to use deadly force, but it's a very limited privilege. That privilege, according to the law, indicates that the defendant can only use deadly force if he reasonably believed that the force was necessary to prevent imminent death or great bodily harm.
Or great bodily harm. Notice how he kind of poo-pooed the great bodily harm.
In determining whether or not those beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances that existed at the time of the offense. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts and not with the benefit of hindsight.
Oh. So
aren't
you going to give hindsight?
The people of ordinary intelligence and prudence who will apply that standard of reasonableness to the defendant's behavior and make a determination as to whether or not his use of deadly force was reasonable. Was it reasonable for the defendant
to believe
that the force was necessary to prevent imminent death or great bodily harm to himself? So, let's talk about the context of that evening.
Look,
and I'm going to try and go in a little bit of chronological order to set things up for you so you understand the evidence as it comes into this trial.
He's not a hero.
The first witness you're going to hear from in this trial is a man by the name of Dominic Black. Dominic Black was, at the time of this incident, dating Mackenzie Rittenhouse, who is the defendant's sister. And through Mackenzie, Dominic Black got to know the defendant. And they spent a lot of time together in the months leading up to August 25th.
What does Dominic Black have to do with anything
In fact,
about this?
on May 1st of 2020, Dominic Black bought the AR-15 for the defendant. That occurred up in Ladysmith, Wisconsin. Dominic Black used money that was given to him by the defendant to go to an Ace Hardware up in Ladysmith and buy the gun in Dominic Black's name. Now you might ask, why was it necessary for Dominic Black to do that? Why couldn't the defendant do that? Because the defendant was 17. And Dominic Black and the defendant knew that because the defendant is 17, he cannot purchase a gun. He cannot legally own a gun. And so this was, in effect, a straw purchase on behalf of Dominic Black, on behalf of the defendant. After the gun is purchased in Ladysmith, Dominic Black and the defendant spent a little time up there at Dominic Black's family's hunting property. And they fire both that AR-15 and one that Dominic Black already had. And the two of them are practicing using their AR-15s at a shooting range.
He's going to say AR-15 as many
and Mr.
times
Black
as
will
possible.
tell you some more about that. Then they agreed that that gun would not go home with the defendant to his home in Antioch, Illinois. It would stay here in Kenosha at the residence of Dominic Black's stepfather in a locked gun case. And in fact, after the two of them returned from Ladysmith in early May of 2020, the gun stayed at that residence here in Kenosha until the day of August 25th, 2020. On the night leading up to August 25th, that Monday night, the defendant stayed over at Mr. Black's residence here in Kenosha. And the two of them decided on that next day, Tuesday, August 25th, that they would
Dominic Black's
do
in
something
Kenosha?
about what was going on in Kenosha.
They were
one
friends?
point earlier in the day,
And
they
he
come
lived in
down
Kenosha?
here.
How could he? He crossed
They worked
state
on
lines
cleaning up
to have
some
a
graffiti
friend?
on some buildings here downtown. Then they decide they want to come back later that night and protect a local business.
Okay.
A business called Car Source, which is located at 59th and Sheridan. Now, as I talked to you a little bit about yesterday, Car Source actually has 3 locations very close in this downtown area. One of them was on the east side of Sheridan Road at 58th and Sheridan. And either on Sunday or Monday night, I think it was on Monday night, August 24th, that entire property was pretty much destroyed. There were multiple cars in the parking lot that were set fire and completely burned out.
So
the building itself was damaged as well.
Is this guy for the
Right
prosecution
across
or
the
the
street from there
defense?
is another Car Source location that also sold used cars. And some of those cars had been damaged on the night of Monday, August 24th. So on Tuesday, when the defendant and Mr. Black are out and about, they encounter one of the owners of Car Source. And they talk to him about protecting their 59th Street location that night. And there's some discussion about that. In the afternoon, Mr. Black and the defendant go out to Jelinski's out on Highway 31, Green Bay Road. And they acquire straps so that they can sling those guns around themselves when they come back to the downtown area that night. And eventually later that evening, they return. They meet up with some other folks that are interested in protecting Car Source. Originally, they start out at 63rd Street Car Source, which is the third and final Car Source location. But then they agree, we're going to go to the 59th Street, 59th and Sheridan location and protect that location to make sure no one damages the cars, no one damages the property. And I want to be clear, there's nothing wrong with that.
Okay. Including the
Protecting
weapon?
that property is entirely lawful. Totally understandable. And it's something that many people here in Kenosha did.
Okay.
And there's a group of people, including the defendant and Dominic Black, that take up positions at 59th Street. Some of them, like the defendant, are on the ground in the parking lot, where as people are walking by in the street, they're having interactions with these people. Dominic Black will testify he took up a position on the roof.
Oh, rooftop
He did
Koreans.
that because he
Is
didn't want to
Korean?
be on the ground, close to where other folks were, close to where potential issues might arise. He wanted to stay a little bit removed from all of that.
Because what did
Didn't
Kyle
want to
do
get directly involved
while he was
in it.
there? Is he going to talk about the first aid he gave to people?
You will hear and see videos of sequence of events going on around Kenosha that night. The evening begins with large-scale protests, large-scale, no other way to put it, rioting that's occurring right outside these windows, right in front of the courthouse here at Civic Center Park. There is a crowd of police that are lined up to protect this building, to protect the public safety building, which is right next door. And there are a large number of protesters that are agitating. They are screaming at the police. They are throwing projectiles. Police are shooting rubber bullets, tear gas, etc. It is a very volatile situation at Civic Center Park. Now, that's at 56th and Sheridan, about 3 blocks north of the car source where the defendant was. But as the evening goes on, the police decide to move the line of protesters south on Sheridan. And eventually, they pass the car source at 59th and Sheridan. The police establish a line at 60th
self-defense
and
is
Sheridan.
always reasonable. The prosecutor's going to have to prove it wasn't self-defense.
Now, as that process is going on, many of these protesters pass by the defendant and the people that he's with at 59th Street. Words are exchanged. There is confrontation. There is a little bit of hostility. No one is hurt. No one fires a gun.
Kyle didn't shoot
No one
anybody
is
then?
injured.
Why
But
not?
clearly there's antagonism. It is clear that this is a crowd that is not on the same side as the defendant, that does not see him as an ally, does not see him and his group as someone that they identify with. And as I said, there is a hostile exchange there for a while. In fact, at one point, members of the crowd pull one of the dumpsters from the property out into the street and attempt to start it on fire. And some of the other folks that are there with the defendant go out and put the fire out and have some very harsh interactions with those people in the street. I believe the evidence will show that it is this process that demonstrated for the defendant that this is a crowd that is not a safe crowd to be in. This is a crowd that does not view him as an ally. This is a crowd.
It's not a safe
that
crowd
if he
to
ventures
be in.
out into it.
So would it be reasonable
there
for
could be
someone in a
problems.
safe crowd to be in who's being attacked to
Now,
have self-defense?
Once the police pass by and the protesters are pushed down south of 60th,
Jesus.
I believe the evidence will show that the car source that the defendant is stationed at is no longer in danger. There's no one there who's attempting to damage the property. There's no one there who's
when did
going
he
to
help
do anything to
put out
harm
the
anyone
fire
there.
in the dumpster?
The situation has moved on.
When did he help put the fire out in the dumpster? Because he's walking away.
Does
and
the
he gets
defendant
confronted.
stay there? Does he decide that he's done what he set out to do and it's time to go home?
This is interesting.
No.
This narrative is
The
very
evidence
creative.
will show that the defendant, another individual in the group by the name of Ryan Balch, who you will hear from, decide to venture out into the crowd. They cross the police line at 60th and Sheridan, and they walk amongst this group of hostile protesters. At some point, they both wind up at a gas station on the southeast corner of 60th and Sheridan called Ultimate Gas. And you'll see some video of the scene there. It is a scene, again, of groups of people that are clashing with one another verbally. There's some shoving going on.
Yeah, it does
And
sound
in
like
the
he's
midst of
making the
this
defense's case.
is Joseph Rosenbaum. And you will hear some testimony about Mr. Rosenbaum and his activities that night. Mr. Rosenbaum had been discharged from the hospital that very day and had come back to his home of Kenosha.
What kind of hospital?
Had met up with his girlfriend,
What
Carrie
kind of
Ann Swart.
hospital? Why was he in the
He
hospital?
couldn't stay with her, so he left her and came downtown and got
Why
caught up in the midst
was
of
he
these
in the
protests.
hospital?
You will see him on videos. You will see photographs of him as he's walking around. He is carrying a plastic bag. Part of that plastic bag is clear and see-through. It has a string, white string, drawstring to it. It is the type of bag, I believe the evidence will show, that you get at the hospital when you're asked to put all of your personal possessions in a bag.
Why was he in the hospital
Your shoes,
again?
your watch, your phone, your jewelry, etc. That's the type of bag it is. And I believe the evidence will show that he was carrying it around most of that evening. And at various points, the evidence will show that Mr. Rosenbaum is agitating. He is getting in people's faces. He is using obscenities. He is essentially daring people to respond. In fact, at Ultimate Gas, I believe the evidence will show that he actually gets right up in the face of armed people who are similarly armed as the defendant, who have similar AR-15 type rifles on. And he is literally confronting them in their faces. None of those folks shoot him. They push him away.
Oh.
He's 5'3", by the way, 150 pounds.
Doesn't matter.
They push him away. No one appears to take him as a serious danger. The defendant is at the Ultimate gas station during part of this, so is Ryan Balch. I believe Mr. Balch will testify that there was an understanding that when we cross south of 60th, we stay together. We try not to intervene in anything. But if we get separated, head back to 59th Street, where our original group is. Mr. Balch does. The defendant attempts to. He comes up to the police line. They won't let him pass. He says, I work at that business, and points to 59th Street. And again, they won't let him directly through the line.
My God, he is making
Now, I
a
believe
case
the
for
evidence will
Kyle.
show that he could have easily gone a block in either direction if he really wanted to go back, but he turns away from the police line, returns to the Ultimate gas station. And a few minutes later, we see him on the video of a man by the name of Corey Elijah, who will testify very shortly here in this trial. Mr. Corey Elijah was one of these people out on the streets who was Facebook live streaming the events of that night. And he catches the defendant passing right in front of him with a fire extinguisher. The gun still slung around his body, strapped
Why
to
did
his
he?
body.
Oh my gosh! So he
And
puts
Corey
on a
Elijah
dumpster
will
fire.
testify, this caught his attention. Where's he going with this fire extinguisher? And so Corey Elijah decides to follow with his video, recording the entire way. And we will show you that video.
So he's a.
You will see that as Corey Elijah
putting
leaves
out
the
a
Ultimate
fire.
gas station at 60th and Sheridan and heads south, he passes by the defendant, who by this point is walking, holding a fire extinguisher in his hand, all by himself. Corey Elijah,
This
I don't
guy's
think
so
registers
it's
that
proving
that's the
that
person
Kyle's
I
a good
originally saw, and he
Samaritan
keeps on
putting out
passing
a
him.
fire.
And as he continues, he passes by Joseph Rosenbaum, who at this point has taken his shirt off. He's got shorts on, and he's taken his shirt and kind of wrapped it around his head. And Mr. Rosenbaum is still carrying that plastic hospital bag and walking down Sheridan towards the 63rd Street car
Walking.
source. The defendant is behind him.
There's video of
some
Rosenbaum
distance.
pushing the dumpster.
As they get down to the 6200 into the 6300 block
Oh my gosh.
of Sheridan Road, that block on the west side of Sheridan has a house right at the corner of 62nd and Sheridan. And then on the south end of that block, the south half,
No,
is the car
Rosenbaum
source
didn't
lot.
have a gun.
You will hear testimony from someone from the FBI who was up in a plane that night taking video. And we will show you the video. It is an infrared video, which means it picks up heat. This is at nighttime, so regular cameras, especially
So
from an
how do
airplane,
they know
aren't going to
who
be
is
able to
who?
see everything. So the infrared helps us to see in the dark. The video picks up Mr. Rosenbaum. It is quite clear to see him because he is a white blob. Infrared picks up heat. He doesn't have his shirt on. So the cloth of a shirt would help conceal some of that heat, but when you don't have your shirt on, that heat radiates, and the infrared picks it up more clearly. So he's very
Rosenbaum's a
easy
white
to see in the
blob?
video as a white dot. You see him running towards the 63rd car source. And behind him, running in the same direction, following him, is the defendant.
With a fire
As
extinguisher.
they get to the 63rd Street car source, there are some cars on the north side of that lot. Mr. Rosenbaum peels off behind those cars, and the defendant stops on the other side of those cars and turns towards Mr. Rosenbaum. Now, obviously, in an infrared video from a plane overhead, we don't know exactly what was going on at that very moment. We don't know what words were said.
So
But
what-
what's clear is whatever that confrontation that was initiated by the defendant started, it caused Mr. Rosenbaum to come around the cars and start running after the defendant.
So after
The
the
defendant drops
defendant
the fire extinguisher right there and runs.
and runs away.
Carrying his
Dad,
AR-15.
You're giving him a.
At some
You're
point
giving
during
him
that
a defense.
foot
He
pursuit,
ran
the defendant
away.
turns around, points the gun at Mr. Rosenbaum, who puts his hands up in the air. Now remember, he has got no shirt on. He's got his hands up in the air, almost like, what are you going to do? The defendant stops, pointing at Mr. Rosenbaum, continues to run,
Runs away again.
and right around this time, there is a gunshot
And they're, oh my
from
God.
someone else, who we have identified by the name of Joshua Zeminski. This is an individual who's walking on the sidewalk, probably
Okay.
30 feet away from where the defendant and Mr. Rosenbaum are running.
Ladies and gentlemen, I'm
Mr.
going to leave
Zeminski,
this
for
on
reasons
until I sign off.
only he can explain, decided
Well, no, 'cause
to
I
take
gotta play
his
my
handgun
outro.
and
But
fire
listen,
it one time in the air.
Thanks for joining me today. This is incredible.
As I
Go
said,
ahead
this
and
is in
click
a
the
different
Yahoo
direction,
link pinned at the top,
many
or
feet
go to
away from
Ranting
where the
Monkey,
defendant
or
was.
Rakita
Mr.
Law,
Rosenbaum continues to pursue
or
the defendant.
Crowder, or
And
somebody.
we will have
Go watch
Detective
it
Martin
somewhere
Howard
else.
testify that he's timed the gap between Mr. Zeminski's shot and the eventual gunshots is about 2.5 or 2.6 seconds. Mr. Rosenbaum closes on the defendant. The defendant turns and fires 4 shots
After
at Mr. Rosenbaum. You will hear the testimony from the Milwaukee County Medical Examiner, Dr. Douglas Kelly, that Mr. Rosenbaum suffered 5 wounds total from 4 bullets.
Interesting.
Dr. Kelly will testify that the first 2 wounds that were inflicted upon Mr. Rosenbaum were to his lower extremities. We're not sure which order they were in, but one was to his right
Oh my
pelvis,
God. Anyway, guys,
fracturing his pelvis.
yeah, this has got to be
and
it for
one
me.
was to
Click
his
one of the
left
links
lower
above or go
thigh.
to the other channels. I got to go. Thanks for being here today.
Dr. Kelly will testify that these wounds caused Mr. Rosenbaum to start falling face
I'm going to
forward.
get rid of my thing here.
And you will see video of his body where it is found. He lands on his face down on the ground. As he is falling, the defendant fires 2 more shots. One of them hits the defendant in the back. Or I'm sorry, Mr. Rosenbaum.
Oh,
in
so
the
he
back.
didn't shoot him in the back.
And that is the shot that kills Mr. Rosenbaum, according
Good
to Dr.
God.
Kelly. You will hear testimony from someone by the name of Richie McGinnis. Richie McGinnis is a reporter who came to Kenosha to cover the events of that night. And at some point, shortly before
And
these
Richie
shootings,
McGinnis- oh
he
my
encounters
God.
the defendant at 59th Street and interviews
All right,
him.
guys, I got to
He
go.
talks to
Thanks
the
for being
defendant.
here. My name's
And then
PDawgKnight.
follows the defendant down
I'm out
Sheridan
of here.
Road and
Click
is
the
right
link. Here's
behind
the
the defendant
outro.
as these shootings are occurring. In fact, he is in the car source lot. He is behind.
This is PDawgKnight, and thank you for watching today on the PDawgKnight channel. If you have an observation or remark you'd like to make about this video or my channel, I absolutely welcome you to write it in the comment section down below. I really look forward to hearing from you. And before you go, if you like what you saw but you're not already subscribed, please make sure you hit the subscribe button and definitely click that bell that pops up afterwards so you'll be notified when I post new videos or when we go live. I broadcast my live show, The Morning Night Live, Monday through Friday at 10 o'clock Eastern, 9 o'clock Central. A special thank you to all the supporters of this channel who share our videos on social media and who make donations through Streamlabs, YouTube, Venmo, and Cashapp, which are all linked in the description down below. Thanks again, and until next time, I'm PDawgKnight, and I'm out of here.